Good afternoon to all of you. Welcome to Legal Matters by Sai Babu Sukara. In this video, we are going to discuss the effect of signature on a blank check under section 139 of the NI Act. This matter went up to the Supreme Court level. If the accused hands over a check duly signed by him as per agreeing his liability, then definitely it will become a legally enforceable debt. This is what is stated by the Honorable Supreme Court of India, 3 judges bench, in the case of Messrs. Kalamani, Textiles and others versus P.Bala in Criminal Appeal number 123 by 2021, SLP 1876 by 2018, decided on 16/2/2001 by Honorable Chief Justice of India, Sri N.V. Ramana, Suryakanth and Justice Anirudh Bose. Right. We'll go to the facts of the case. The appellant, that is Kalamani, Textiles and others, as well as Mr. P.Bala, they were all partners, or they did joint business in exporting garments to the country France. Actually, P.Bala was already handing over the export business under the name of Growell International, and these people, Kalamani Textiles, they have also joined as partners. And for some time the business went well, but ultimately as time proceeds, there were disputes. The disputes arose between Balasubramaniam as well as Kalamani Textiles regarding the delay in the shipment. Normally in the early stage they will start the shipment immediately, but of late, so normally due to the delay, other side, the people in France, they might have given the money also. Delay in shipment and payment from the buyer. Dispute is regarding that. Anyway, the accounts were settled. Ultimately, the appellants, that is Kalamani Textiles, they are due an amount of 11.20 lakhs to Mr. P.Bala. Therefore, on behalf of Kamal Textiles, one of the partners, he has given a signed check. He is appellant number 2. He issued a check for 11.20 lakhs with check number 897993 on 7/11/2000. Besides that, he also executed an undertaking on the same day, wherein he undertook to repay the entire amount. Of course, a time was given, 1 month or so time was also given. Please remember, here two issues are there. Number one, he has given a check, and at the same time he has given undertaking. When undertaking is there, he will claim. We will come to that part also. Now, on 29/12/2000, the check was bounced. Notice was given on 8/1/2001, but the appellant number 1, he denied his liability, or the appellants denied their liability. They alleged that the blank checks and the signatures on the white papers, they were converted into the so-called check as well as the demand deed of undertaking, and they have misutilized them. Therefore, there is no necessity for them to repay the money, and their claim is that it is not a legally enforceable debt. So, he could not prove. There is no other evidence for the appellant Mr. Balasubramaniam, for the respondent. So therefore, the case was dismissed by the trial court. So even though he filed the case under section 138 of the NI Act, before JFCM Tirupur, the case was acquitted because he could not prove the case beyond all reasonable doubt. Because they have raised that point. There is a deed of undertaking, there is a check. So deed of undertaking has to be given preference. So without that, the check cannot be bound, without a check cannot be sent to the branch, and as a result of which it bounced. So therefore, anyway, since he could not prove the case beyond all reasonable doubt, simply the trial court dismissed. Then he went to the High Court. So High Court, please remember, it held that it is a legally enforceable debt because the signature is there under 139. Signature itself draws a presumption that he has issued the check. And second point is the appellant, that is Kalamani Textiles, they could not prove whether it was stolen or not. That means whether when it was stolen, what they have to do? They have to give a police report. It was not given. That's the point there. So anyway, High Court took it as a legally enforceable debt and asked them and fined rupees 5,000 or so to A1 and also to A2 also fine and imposed a punishment for 20 days and 1 month. So therefore, agreed by this, they have approached the Honorable Supreme Court of India. So Kalamani Textiles has approached the Supreme Court of India. So now the matter has come before the Supreme Court. In the meanwhile, actually for going in appeal, he has to pay 50% of the amount. This Kalamani Textiles, they have paid 11.20 lakhs on 11/4/2018 because it's a legally enforceable debt. So the advocate on their behalf once again started the same argument stating that the stamp papers were stolen, the checkbook was stolen, they have been tampered, all these things. They are misused by the respondent like that. But please remember, Supreme Court noted that the signatures are undisputed. This is most important point. Signatures on the check as well as signatures on the deed, both of them are undisputed. So therefore, he has got the liability. It shows the liability. And here please remember, so if he does not pay the money, definitely miscarriage of justice will be done. And here Supreme Court pointed out of the NI Act also. The provisions of NI Act, they are not only punitive but also compensatory. This you have to remember. That's why jocularly I have been telling you, we don't know whether NI Act case is a civil case or criminal case. Supreme Court clearly said that it is not only punitive, that means criminal, but also compensatory. It is a single window system, single window act for criminal liability and civil liability of the owner. Therefore, A2, of course, since he has promised, he has taken the deed, he need not go undergo the punishment of 20 days. Whereas A1, since he has failed to repay the money within the proper time, he has to undergo 1 month time. Normally, you all know that twice the amount they have to pay. Luckily, since they have already paid the money in 2018, so the money has not been considered as a question. Only thing is punitive nature. So A1 is convicted. Anyway, good point. So in this case, what you have to learn is when you sign on the check, when your signature is found on the check, even though it's a blank, that means even though the other columns are filled up by somebody, the liability lies on you. Either you have to prove that it is a false signature or forged signature. Otherwise, the liability is encumbered on you. Very good case law. Please read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.